mindful of time, there's a sitting this afternoon as well. And if I may now hand over to the Deputy Minister, who will make introductory remarks, and then the liquidators will have an opportunity then to make their presentation, which I assume, colleagues, you have all received. If not, please just indicate in the group, and then I'll request that, as per normal, the speaking list, you just indicate for me in the group. So, Honorable Deputy Minister, I'll hand.
Honorable Chair.
Yes, good, Honorable Hart.
Yes, no, Chair, I'm having a concern. Honorable Tolashe, she's struggling to log in. She's been waiting for 45 hours. And this happened to me last week. I was cut off and I could not participate in the meeting. And I think it's unfair for members not to be able to participate in a meeting, especially if it's not their fault. I did not take it kind last week when I couldn't participate in the meeting until 2 minutes towards the end of the meeting. And now it's happening to another member. I do not think it's fair, especially if she's been trying to log in for the past 48 hours. I mean, 45 minutes, I'm sorry.
It's fine, that is noted. Sis Ntombi and Ben will take care of that particular aspect. It's duly noted. I think we are all still trying to grapple with the realities of this new normal. Sis Ntombi, if you can please assist Mumam Tolashe on that other end, and then proceed to the Deputy Minister.
Thank you very much, Honourable Chair. Greetings to you, greetings to the honourable members of the committee and all in attendance. I will not really take much of the time because in your introduction you did give a fair background to the meeting, to which last week I submitted on behalf of the department our apologies to the committee, and we undertook to have the matter remedied. We have in the presence in our delegation the attendance of the Mr. Aviwe, as well as he will talk to the other colleagues he has from the team of liquidators. I have from the department the Director General, as well as our Head of Legal Services, Mr. Melanchthon. We would be happy, Chair, after the presentation of the liquidators, to engage with the committee in all matters they would take interest in. The matter that I undertook to establish as to what upon we looking as to what happened. So without much ado, Chair, can I, with your permission, hand over to the liquidators?
All right, no, thank you very much, DM. Let us hear from the liquidators. He will introduce his team and emphasize to him the need why we wanted them here and that they will continue to appear before us is precisely because they are the accounting officers of the institution at this point. And therefore, whatever circumstances, they are the ones whom we expect to appear before us. Right? The liquidator, over to you.
Good morning, Chairperson. Good morning to the honourable members of Parliament. Chairperson, thank you for this opportunity. Just as a form of introduction, as the DM has introduced, the facts, Chairperson, relating to perhaps our apology and our unfortunate non-appearance last week were as follows, Chair. We did indeed get the invitation on the Friday afternoon preceding the Tuesday. Friday afternoon at about 4, and then subsequent to that, there was other emails that were sent. However, Chair, you know, we are liaising with the department on various other communications. It really got to our urgent attention on the Monday prior to to us appearing and having to appear with a proper presentation on the Tuesday. Chairperson, that is not an excuse, from our side. We want to, and I'm saying this indeed on behalf of my colleagues. We have discussed it extensively. We want to sincerely and profusely apologize to members of Parliament, to the committee. There was certainly no intention whatsoever to undermine this process. There was certainly no intention whatsoever to offend the members of Parliament. I think we thought it just that indeed perhaps there would be a much more meaningful discussion if we were then given just this opportunity to give a proper report. And now, Chair, this report basically deals with, one, the actual legislative framework that governs this process. Indeed, for practitioners, for the industry, it is uncharted waters. But we want to make it very clear to the members of Parliament that we indeed respect the process, and at all times we will be accountable, transparent, and we sincerely hope that our apology could be considered in a favorable manner. So, as a form of introduction, we sincerely apologize for that misconnect that happened last week. Now, Chair, I'm not certain if I may then continue with the report. May I confirm that if all the honourable members have the presentation?
Yeah, the presentation was sent. If you may put it up as well. And I did note that you go at length in your presentation about the legal framework and the explanations about what you are supposed to be doing. And I think it's only starting in slide 14, I'm subject to correction, where you really get into the substantive matters related to SA Express. I would request that you speak very briefly to your legal obligations, and then we deal with the substantive matters related to SA Express so that we can actually save time. And so far as your apology is concerned, difficult position last week when we had to take a resolution that if you do not appear, we subpoena you. It should not have to be that way. So I hope that that will be understood very clearly moving forward. But as colleagues, we will consider that and discuss that apology at a later stage. I request that we now get into the substantive matters. So, the liquidator, if you can proceed, and also introduce, of course, your team with which
Yes.
you are working, so that we know who's here. Right, colleagues, are we fine? All right, let's proceed. Right, the liquidator. It is now 9:10. I will give you until just after 9:30, and let's see how far you can go. All right, let's go.
Thank you, honourable members. I have my colleague Soria Magelas Pantelis, who's my joint provisional liquidator. I have my other colleague Clifford Maredi on board, and then I have Hannes Muller, and I think I've got my other colleague Chris Miniela on board. If I may, Chair, sorry, Chair, I just struggled to attach my now presentation. I would just need some help to share it. I'm not quite familiar.
If you can assist, please, and Lebo, I know you had a crash course before the meeting started on that, if that can be done, because yes, committee members may have it, but there are other members of Parliament joining who may not have it. And this, so we would need to have the presentation up. So Lebo, if you can assist, please.
Okay, okay. Yeah, thank you very much. I feel the same way we did it to my brother.
Okay, okay, I'm there.
There we go, yes.
Okay, now Now from here, I think this is the.
Yeah, you can.
I'm in now.
You're going out. You got out of it again.
So I just want to go to the to the email. Okay.
You're completely out now.
There it is.
It's not there,
Okay.
my brother. Aviwe, it's not loaded.
Yes.
It's not loaded. You went out of your sharing function.
Okay. Can I now?
Go back to your sharing function and
Share.
upload it properly. Yeah. You were there, but you decided to go out. And the chair was warning us of time. I think this is gonna take time. Don't you want to try it just again, my brother? You are completely out now. We see ourselves as participants. No sharing features.
Can this presentation be emailed to the ICT guys to put up so that we save time? Actually, this should have been done prior. We're now going to lose a lot of time because of this.
It's emailed.
ICT,
emailed.
do you have the presentation? Please put it up, and you will then be guided by the liquidator and so far as what slide he's at. ICT, are you there?
Sorry, Chair, I'm also battling. I'm just trying to share it now. Just give me 2 seconds.
Colleagues, I'm sure that all right, colleagues, because you've got the presentation, I'm really trying to save time here. Can we proceed, please? And colleagues will open up their presentations on their sides. Right. Right.
Honorable Chair, the
Yes.
presentation was forwarded to us, meaning that our office staff has the presentation. Why can't they load it from their side? I mean, we got the presentation from.
No, the problem is there are other members who are not part of our committee who have joined the meeting, and therefore the rules dictate that the presentations must be put up for the benefit of them, because
Yes,
they must. Yeah, but what I'm saying is that now we will proceed.
Upload the presentation because they have it, instead of us trying to wait for the liquidation to upload.
Yeah, but IT is having problems loading it as well. So it seems to be a problem across the board. And I'm saying that, can we at this point proceed? Right, there it is popping up. Right.
Framework, and then we will then deal with the substantive matters regarding the status of the liquidation proceedings. Now, what is the aim of liquidation? Honorable members, it's when a company is unable to trade owing to being insolvent, the company's assets are then liquidated. The assets will generally be sold by way of a public auction, by private treaty, and in most cases there are many transactions where we sell the businesses as a going concern. The proceeds from the sale will then be utilized to pay the costs, charges, and expenses that are incurred in the administration process, as well as then dividend liquidation process. This is in terms of South African legislation. As it currently stands, a distinction must be drawn between a solvent company and what is deemed to be an insolvent company. Now, the administration of all insolvent companies are governed by the Old Companies Act, together with certain provisions of the Insolvency Act. The regulation and the entire administration process is then governed by those acts. Effectively, an application to court can be brought by an affected person, a creditor, or a shareholder. Then, now the duration of a liquidation process. The Office of the Master of the High Court appoints and supervises liquidators. Once a company is in liquidation, whether final or provisional, liquidators are then appointed to administer those proceedings from the beginning up until the end. Liquidation proceedings can take anything from 6 months to 3 years. The duration all depends on the nature and the size of the estate, as well as the complexity of the transactions the company entered into. Now, what happens to management of a company whilst it's in provisional liquidation? When a company is placed in liquidation, the company remains a corporate body and retains its powers, but will, from the date of commencement of the liquidation proceedings, cease to carry on its business, except insofar as may be required for the winding up of the company by the liquidators. Then the general duties of a liquidator. The general duties of liquidators are found in sections 391 to 410 of the Companies Act. The relevant sections are mandatory. Thus, in each case, the liquidator shall perform the duties stipulated. The Act first stipulates general duties, and then it lists certain specific duties. The general duties in general are the following: to proceed action of the cost of the liquidation, the claims of creditors, and to distribute the balance, if indeed there is a balance, to those who are entitled to receive those dividends. Then there are specific duties of a liquidator. This is now to give information to the Master of the High Court, to facilitate the Master's inspection of the books and records of the company, to examine the affairs and transactions of the company before its liquidation, in order to ascertain if any of the directors or officers or any of the past directors or officers have contravened any provisions of the Companies Act, or if there were offences that that happened prior to the liquidation. Where appropriate, then liquidators must report any grounds to disqualify a director. Inter alia, the shares issued by the company, its estimated assets and liabilities, the causes of the failure of the company, and indeed would have to report on the status of the actual winding up of the company. Of significance is the fact that the liquidators will have to note whether further examinations, in their opinion, is desirable regarding any matter relating to the promotion, formation, or failure of the company in regards to the conduct of the business. The other part now, we come to the issue of creditors. Creditors' claims are filed on affidavits and supported with the necessary evidence to indicate that the company is in fact indebted to that particular creditor. A creditor must file his or her claim with the liquidator, alternatively at the court where the first meeting of creditors will be held. Thereafter, if a creditor wishes to file a claim, he or she may request to convene a meeting at which the creditor will file his or her claim. The cost of convening such meeting will be for the creditor's account. The said meeting is referred to as a special meeting of creditors. Only creditors who have proven their claims will benefit from a distribution, which is usually a portion of what the creditor is owed unless a creditor is unable to rely on this. 0.7 billion. Each creditor in the liquidation process will have to file a claim in an affidavit to confirm and prove that indeed they are owed an X amount against the company. Now there's a ranking of creditors' claims. Creditors claimed are ranked and paid in accordance with an order of preference determined by the Insolvency Act. Once the cost of the winding up have been paid, creditors will be entitled to their proportionate share of residue of the company's estate. Preferred creditors are entitled to be paid before the concurrent creditors. Secured creditors are those who hold security for their claims, and they are paid from the proceeds of the sale of such security they hold. The examples there would be your mortgage bond, your installment sale agreements, etc. Concurrent creditors, including preferred and secured creditors whose claims have not been satisfied in full, are paid out of the residue of the estate and are the last of the creditors to get paid. Now, how the liquidation process is terminated. Once the affairs of the company have been wound up, and if the liquidators have complied with all the requirements of the Master of the High Court, the liquidator may apply in writing to the Master for a certificate to that effect. The Master of the High Court shall, when he or she issues a certificate, state that he or she consents to the reduction of the bond of security by the liquidator to a stated amount for cancellation. The liquidation and winding up proceedings will then be terminated. This, of course, will happen after we've drafted a final, the last liquidation and distribution account and paid all the creditors in accordance to that account. Now, Chairperson, now to come to the procedural element, we've had meetings with all the affected parties. We've had the circulars circulated. We've had an introductory meeting with the department. We've had an introductory meeting with the former board of SA Express, and we've had introductory meeting with the SA Express Association, the Pilots Association. We've had a number of meetings with the various unions, and of course, we've had various engagement with the leaseholders and the creditors. The status of the final liquidation order, as has been made public, the extension has been the provisional liquidation order has been extended to 6 September 2020, and then we've subsequently made an application to court on Monday and have extended our powers as the provisional liquidators. And there was an issue regarding when we were appointed, the Master of the High Court issued what we deem as a bond of security to the tune of 1.8 billion. Now, the premium payable of that would be to the tune of about 9 million per annum. It was imperative for us to take charge, do an independent valuation, and then be in a position to give a fair related market value of the assets of SA Express, which we have successfully done, and that bond has been reduced to the amount of 113 million. Now, talking about the bond issue was one of our priorities when we got appointed. So a security bond protects the assets of an estate from any negligent acts. It protects the creditors and other beneficiaries of the estate. On the appointment of the provisional liquidators, the Master issued a bond of security in the amount of 1.8 billion. The premium payable for that would be payable from the expenses in the liquidation. So the immediate priority was to complete an interim independent valuation to be submitted to the Master. in order to give a proper indication of the market value of the assets and reduce the bond. So we've successfully done that. We've reduced that bond. The current lease, there are currently ongoing lease agreements in place of offices and hangars to the tune of no less than 2.2 million rand. There are ongoing aircraft and engine lease agreements to the tune of no less than 22.5 million rand. So immediate consideration. Now, honorable members, this is critical for us as we of engaging a process of a sales process or alternative of the lease agreements will certainly have an impact relating to the licenses. But that's a process that we are engaging and would have to, whilst the employees as of 28 April 2020, the granting of the provisional order, the employees' salaries were outstanding for March and April 2020. The outstanding remuneration will be dealt with as claims against the company. We have continued with TARS UIF for the month April and May. We have completed all the statutory documents, which is now the UI 19 forms, the salary.
Mr. Liquidator, there's a running commentary of a fidget. All right, you can continue, sir.
The cash position as of date of appointment. What was sitting in the SA Express bank account? What would have quantified was an amount of about 800,000. Now, these proceeded to appoint or appointed the payroll manager, the former payroll manager, to assist us with an audit and reconcile this must benefit in terms of the insurance product regarding this 800,000. So these funds, we were not in a position to utilize these funds. Now, one of our first duties is to obviously get control and do a proper investigation of the company's affairs. At this point in time, the investigation is related to what are SA Express's assets, who are the creditors. As I say, our request is some assistance from some of the technical former employees paid, and we appreciate that. We have utilized thus for our own resources to the tune of no less than 300,000 rand in order to fulfill these obligations as administration process. There was the provisional order. My understanding is that NUMSA, as well as two other unions, also supported the extension. Now, our rationale and our reasoning is that the implication of a final liquidation order will result in powers which we have successfully done on Monday by the shareholder or the equity investor. A final liquidation order at this stage, prior to engaging a sales or an investment process, would result in the company, wherein the extension has given us an opportunity to engage a sales process pending the termination of the licenses. Now, in accordance to retire at the end of July, and we have one particular license that is scheduled to expire at the end of December 2020. Now, whilst we engage this sales process, we'll be actively then engaging with the CAA and the prospective purchaser in order to understand the requirements for us to make an application for an extension opportunity to explore a possible further. The airline holds two licenses. The engage is to how will the employees get paid. The employees' claim documents have been completed. The claims will be claimed is once a provisional order, a liquidation order, has been granted, all rights of creditors are taken into consideration. Essentially, as of date of that liquidation order, all creditors would have to, in regard to the legislation framework, prove claims against the company. That has been done for the employees where claims have been completed. Then those claims will be proved during the course of the liquidation and special preference in terms of insolvency law, but are only paid after the secured creditors have been settled. At this stage, it is unclear if there will be a residue for the of how much the liquidators have been paid thus far. Honorable members, we are the last to get paid as liquidators. It's a total different process, total different legislative process from a business rescue process or business rescue practitioners. We are the last to get paid. If, for example, if I anticipate that the matter to fully wind it up, it will take perhaps maybe 24 months or maybe 18 months. We will only get paid once we've completed the full winding up of the airline, drafted a liquidation and distribution account. Once the master confirms that account lies for inspection. It lies with the master of the High Court. It's subject to any affected person looking at it. If there's any objections to it, they may object, but we were the last to get paid, and we can only get paid once we frame the liquidation and distribution account. Now, the liquidators only get paid once the liquidation and distribution account has been framed, lodged, and confirmed by the master of the High Court. We have not framed the liquidation and distribution account. The said account can only be framed after a sales process has taken place and proven claims against, and the company and the creditors have proven claims against the company. Whilst we have not received any payments, we have thus far expended our own resources to the tune of not less than 300,000 rand. The route to be taken and cost. The provisional liquidators request an extension of our powers, which we have successfully obtained. Upon acceptance, we shall continue with the investigation of the affairs of the company and engage a sales or an investment process. We are not administration expenses. We are that we are currently engaging. So, Chair, the next route for us is to proceed with an investment or a sales process, transparent process, where we either attract disposal of the assets of the airline in order to satisfy.
All right. Colleagues, I will proceed to questions. I'm just trying to get the video first off the bat. Then Honorable Somio.
Thank you, Mr. Chairman. Abiwe and your team, thank you for joining us today. We've got two presentations to work from, the one that we received for the last meeting and your current one. So I'm going to kind of move around, but let me start, Deputy Minister, by asking you a question. Treated differently from SAN. Why is there a difference? Why are the employees being treated so differently in terms of the two state-owned airlines, neither of which should be state-owned? Our position has always been quite clear about that. But why are they being treated so differently? Who is meeting the employees who are outside the DPE offices as we speak? Are they then, in terms of the liquidators, on the slide from the previous presentation, and it actually feeds into the closing remarks now, Aviwe, you now say there's 7 interested parties. In your previous presentation, there were, I think, 2 interested parties, but apparently you were looking at parties. What funding? Are you expecting them to come along and take over all the liabilities of the company? What exactly is going to trigger a sale to an interested party? Have you had any direction from the Department of Public Enterprises, or they may not dispose the assets and or the whole airline to? Have any restrictions been placed on you or attempted to be? You indicated that there was a bank that was prepared to provide post-commencement funding, but that didn't materialize apparently because in terms of the amount, please correct me, but my understanding is that these amounts haven't been paid for over a year. What action have you taken to hold the accounting officer at the time accountable? Have charges been laid? On what basis was this not paid? In particular, the CEO who ran away into a top job at Transnet, Cesar Zimela, have you made any attempt to hold her accountable? Aviwa is September, but the licenses expire on the 31st of July. What exactly are you hoping to realize for these licenses? Is it 20 Rand or is it 200 million Rand? On what basis do these licenses make it so attractive, and the chances of any dividend ever getting paid to creditors? You yourself are indicating even preferential creditors in the form of employees are not likely to receive a dividend of any sort in liquidation. Indeed, I'm curious, Aviwa, in terms of you've now invested 300,000 here. You're indicating that there's not likely to be a dividend. What exactly is going to be your bill at the end of it that you're going to try and recover? So there's 300,000 you've put in, but you haven't yet billed the company for what we're looking at. Let's say if this process went on to the 9th of September, the costs, your costs specifically of you and your team for liquidating. Mr. Chairman, I'm sorry I'm taking a bit long, but please bring me to order. But
we will have a second round because I think we're doing well for time.
Okay.
Yeah.
All right. Then I'll stop there, Mr. Chairman. Thank you.
All right. Honorable Stormio, then Honorable Hadebe, then Honorable Swartz, and then Honorable Ment. I think we're doing well for time, colleagues. So I think later we will share the time. Honorable Stormio, over to you.
Thank you very much, Honorable Chair. Good morning, colleagues, the Deputy Minister and his team. In appreciation of the presentation, there are a few questions. I think Lias has asked quite a number of questions which I had. One of the questions I have is that which process, how could you tag the current process that you are engaged with? I'm asking that question, eager to know as to when do you think we are going to arrive at a point when you would say, now I'm starting with the sales process, which you have categorized in terms of your presentation, that you could somewhat through liquidation process consider selling whatever you have in terms of the airline. Looking into the size of your creditors, which could have been a trigger in terms of your provisional liquidation process, would have required substantively to have a gain into the current process of liquidation. Have you then quantified actual amounts against which you should somewhat engage with your creditors? Do you have any assets? Are there any assets that you are working against, both in a forward move, or looking into the backward move in the instance of your choice, whether you and the last area, which is an area of appreciation, is the area that relates to your ability that you have somewhat progressively moved on in terms of honoring your payments as per the court injunction through which you have started to pay off, which is a really appreciable instance that there's been progressive movement around such in terms of what we think would possibly move your process or move yourself towards a fair of the airline. Thank you very much. Thank you very much, Chair.
Some of my questions deal with liquidator. I'd like to get an understanding from your presentation. You have indicated, which already has been granted, that your strategic view was to expand your power either from the shareholder or the equity investor. I'd like to get an understanding, how much are we talking about? How much funding are you looking at? And secondly, what will happen after the 31st of July proceedings? What will then happen? The next question is that the employees claim, you said it's payable from free residual of liquidation, but you are indicating that at this stage it is unclear if there will be such. Moving right along, Chair, I also want to get an understanding at what stage are you in examining the affairs and the transaction of the company as part of your mandate to ascertain if there are any directors and officers and past directors who have contravened any legislation. I'm asking this for 18 months to the employees, but that money had to rely on that COVID-19 relief fund to pay the employees. So clearly, from a layman's point of view, there have been contravention and transgression, and part of your mandate is to investigate such. Have you done that, and at what stage are you? Let me pause there for now, Chair. Thank you.
Okay. Honorable Swartz.
Thank you, Chair. And they are talking 100 things in one presentation, and they also contradict themselves in what they want to achieve vis-a-vis who they are disadvantaging in all that they are doing. They are more worried about the impact of the leases and the licenses, and the terminations of licenses, what impact it will have on leases. And at the same time, they've already used 300,000 of their funds, which they are not telling us whether they are going to charge interest or not on it, the monies that they are using from their own pockets. They are talking about employee salaries, but not showing an interest of how these employees are being impacted, Chair. Because it takes me back to where we come from with the business rescue people, that they never planned and never had the interest of saving the airline at all in the first instance. Because the liquidators are talking about the employees as a maybe, by the way, issue in this whole process, when those people are the most affected people, because then they're talking about the funds, then they are excited that they've got an extension. In the process, they start talking about a purchaser. So you get lost, Chair, that 1 minute they are talking about liquidation, 1 minute they are excited over an extension and looking for funds, and at the same time, they are talking about the purchase of assets. So you don't really get what really that we are dealing with the same type of people, business rescue and the liquidators, that for them, it's about what is in their interest and not in the interest of South Africans. Thank you.
Okay, Honorable Mente.
Okay. Chair, thank you very much. Thank you, Chair. Can you hear me? Can you hear me, Chair? Oh. Something is happening. I don't know.
Honorable Member, we can hear you, but there is feedback or other noises, so you can proceed.
Okay. Thank you, Chair. Chair, my first question is also in line with the slide on specific duties. It's at the beginning of the presentation. What I want to know, a direct question, and this question emanates from a presentation made by the BRPs to appropriations in explaining the expenditure of the company and the investigations thereof that they were undertaking in saving the company. Now, there's 2 pages of There is 2 pages of investigation from that was not paid over. The carelessness of all the allocated funds to the company that were not spent appropriately. My question is, out of the specific duties to disqualify directors, how many directors are linked to the investigations which were given by the BRPs? How many of those directors you have identified and have paid those directors who caused chaos and plunged the company into the financial crisis that it is in today? Number 2, I understand that the company now, you have started the liquidation processes, and it means you have to undertake the process of checking how many of your assets you are having and everything so that you see the value of the company. However, there is full access. There is full access of third parties to the aircraft, like those that are leasing out the aircraft to you. Mama. Hear me, Chair. My network is very bad here. It's indicating red things. Okay.
There are kids on the background that keeps on calling Mama. I don't know which mic is it that it's on, or is it Honorable Mendez mic? Can you please check and switch off whoever is having those kids calling, please?
It's fine. Let's proceed. IT.
So there is a company, Lighthouse, who has full access to the aircrafts, repairing the aircraft, liquidation of your assets. So if you have a third party that have access to stores, have access to aircrafts and everything, that can devalue the company assets because people can steal things. I do not know the logic behind that, but if then there is logic and understanding of why is such happening, that third parties have got access, you can explain to us. My experience after visiting the workshops of SAA Technical was that people are stealing a lot of things. That could be happening now.
But had a better opportunity to position yourself proper. You are really battling.
It's very bad. Then, okay,
Yeah,
Chair, I'll come back again later.
Yeah, okay, no, that's fine. All right, colleagues, we're going to give the liquidators an opportunity to just say, liquidators, I think you need to clarify us here quite extensively. You seem to still be at investigative stage about everything, trying to ascertain a lot of things. Of course, that should form part and parcel of the work that you are doing. But what it indicates to me is that you may also be saddled then with the situation of poor record keeping, which you have found in the institution. If you are taking such a long time to arrive at factual conclusions. Now, that being the case, it leads me to the point that the problems at SA Express are not new. And we have been on this slippery slope as to the role of the department insofar its own responsibilities are concerned for overcall a systematic collapse of SA Express. Because we did not just wake up with SA Express having crashed. I'm sure that the warning lights were there, they flashed, they flickered. In the 5th Parliament, we had serious problems with SA Express, and despite interventions, despite engagements, things just did not move. So I found the flip side of that coin is the department explaining its own role and diagnose the problem correctly. We're going to take what I can only call to be careless decisions. Management on one hand, and from the liquidators, whether they had found, whether as business rescue practitioners and now the liquidators, whatever role, whether consequence management was taking place at SA Express. Because it's fundamental that we arrive at understanding whether the people responsible for the collapse of SA Express not on the radar of either the department or the liquidators, then colleagues, I would suggest that we need to devise a process of some sort, because it's clear that SA Express. I think that for me, that missing link remains an integral part of the puzzle. Because we are certainly not doing justice to the process if we pretend as though the liquidation process exists in a vacuum. It must be put in its context, and that context is the systemic collapsing of the institution, deliberately so, by certain sections of its management, of its boards, as the consequences of their action and their corruption. So I'd also like the the liquidators to comment on that particular one, a sense as to whether these processes are being engaged with honestly and genuinely for the collective interests which have been defined, or it's a cosmetic exercise to shield people from accountability for their actions. Right, so DM, I will hand over to you, or if you'd prefer for the liquidators to start, maybe you start with them so that you can come in, but I think don't lose sight of the questions that have been put to you. All right, Mr. Liquidator? Yeah, Mr. Liquidator?
Okay.
With the Commission Chair. Honorable Chair. Honorable Chair.
Yes, DM can hear you. You can proceed.
Yes, no, thank you, Chair. I was saying, let me perhaps, meanwhile, just come in as you've made in respect to the department. I think there's some echo from somewhere, I don't know, but it's not from my end. I'd like to say, Chair, the problems of the SA Express we're dealing with today have a particular history in which they have evolved. Just to cut the matters short, I want to take particular interest in the board that came into place, I think in 2018, thereabout. The board that was charged with trying to secure a turnaround for the institution. You would recall the airline at the time, aviation standards in terms of the Civil Aviation Authority. And it took a period of time before there could be some funding secured to get the airline back into operation. And as it got back into operation, it almost was struggling with an investigating team that needed to be investigated and having people who need to answer for those things being taken through processes to ensure that they are indeed made to answer for those. It was during that time.
Olive, can we please just really, I hate repeating the same thing over and over again. If you're not on the platform, please mute your mic. At DM, you can proceed.
Yeah, to what it is today. And along the way, a number of interventions have been made in actions by the board. I'm speaking specifically to that board. The board that is still in place, but of course, with a lot of its members having resigned for a variety of reasons, given the introduction of the business rescue practitioners, etc. They would have been filed by the board and the executive management cases further for prosecution in terms of our investigative authorities, which was part of attempting to get to the root of some of the corruption that we've seen in that particular state-owned airline. I just wanted to say, just as we have to ask those questions continuously, I think we've got to be, to appreciate, not that I'm suggesting we're not, we've got to appreciate that there's a bit of background to this for which we can bring some proper account and report at different stages what has happened in respect of that. But again, there were funding issues that the airline faced continuously, even where there would have been amounts of money made available, they would be specifically designed to be able to helping the airline to actually grow its footprint, its enterprise, so to speak. I'm just saying the problems we're dealing with now have that kind of history to them. Coming to Honorable Lisa's question, firstly, just in respect of if there are workers that are at the department as I speak, I'm not there, but it is policy that wherever there are employees or any people who come to the department with any concerns, they will be attended to with the view to getting to have them ventilate what a differentiation between employees at SAA and employees at SAX. The only difficulty I think that makes us to really get to appear to be acting in that fashion is that these entities exist as separate entities. When they are dealt with lawfully, they are dealt with as separate entities. I think it is out of that there is this unfortunate situation in which employees in the two are treated differently, so to speak. Where I think we have got some further work to do as the department or as the shareholder is to revisit that matter to see as to how there is an equity insofar as the employees are treated. Honorable Lisa's concern, though, with this, for me is a little confusing in that at one level, yes, it's the justified concern in respect in place to try, even in the worst scenario, to retrieve a better deal for workers. Mr. Lee seems to be concerned with why elongate this? Why not deal with it now? I think there's a bit of a contrast in that, but maybe it's not for now, it's for another time. We're dealing with a very difficult situation at hand. It has a particular history to it, but we're trying as best to have it dealt with as humane as possible. I think I should leave it at that, Chair. Hopefully the liquidator then can deal with the stuff that relates to the process. I hope they are ready now. Thank you.
All right. Thank you much, DM. We'll hand over to the liquidator. Colleagues have noted for the follow-up round of questions. The liquidator.
Thank you, Honourable Chair. Thank you to the honourable members for the questions. Now, I'll start with the questions of Mr. Honourable Lees. Now, Mr. Honourable Lees, I think we must separate two processes. This is our first presentation in our capacity as the joint provisional liquidators. My assumption, Honourable Lees, would be that you are referring to the business rescue practitioners' previous presentation. Now, I am privy of the contents of that presentation. There was an indication, and that was unsuccessful. I think it was, if I'm not so wrong, to the tune of about 300 odd million or 600 odd million that they requested. And that post-commencement finance was requested by the business rescue practitioners in the business rescue process. We as liquidators have only been in office from the 13th, officially from the 13th of May 2020. So I think to deal with that post-commencement finance question, you're referring to a presentation that was done by the indeed by the business rescue practitioners and not the liquidators. Then the issue of SARS accountability, certainly they are extremely early in the process, in the liquidation process. It is extremely early stages. There certainly will be, if you look at what is deemed to be a Section 417, 418 inquiry, where then we will be investigating all of these affairs or transgressions that would have happened prior to the business rescue and prior, of course, to the provisional liquidation. So there's a mechanism that were perhaps committed by the previous management will then be cleared out within that inquiry. Then regarding the extension of powers and the value, why the extension? Honourable members, we're running a parallel process. As indicated, when will this process begin? This process will immediately begin. We're just waiting for our court order. We'll then engage and then start running this sales process. We don't want to eliminate the possibility of an interested party who would want to cancellation. Will eliminate that process. Essentially, if these licenses, the order was granted and they terminated, we purely in our capacity as liquidators dealing with a sales process. There will be an elimination regarding an investor into the enterprise. So we want to keep that option available. Then the 300K relating to the resources, we had to employ the services of the former employees to assist us to get to a reduced, a market-related valuation. It was urgent. And the employees not having been paid for the past 2 months, it was impractical for them not to be paid for the services that they would assist us in fulfilling our duties. Any amounts or funds that are then that we've funded would be then amounts that are payable within the liquidation administration process. For example, let's say we indeed conclude a transaction, whether it's a administration expenses will be paid, the funds that have been utilized for administration expenses will be paid from those proceeds. Then just to go to Honorable Somyo's questions, when will the sales process start? Honorable members, we got our application, which was urgent, in order to immediately start this process. So we are empowered to start the process, and we will advise all affected parties the process that we will be following in order to procure either equity investment or to proceed with we'll obtain all of these offers, whether it's for the restarting of the operation, whether it's for the sale, and then we'll put this to the body of creditors and affected parties prior to the acceptance. It's going to be a transparent process that will be followed. Okay. Now, thank you. And the second question from Honorable Somyo, the quantification of the creditors. In terms of the February 2020 management accounts, there was a reflex amount, and this might exclude the guarantees payable by the guarantors. We're talking about 800 odd million rand. If we'd had to thumb suck the amount, but those creditors would have to prove claims against the estate in due course. Now, does the company have to speak to what the Honorable Chairperson referred to relating to books and records and the accuracy thereof? When we took office, the estimated assets were quantified to be 1.8 billion. This past 5 weeks, in light of the COVID regulations, to an amount to be quantified at this stage to 113 million. So there's significant differences. So what asset are we dealing with now? If we had to dispose of the asset, what value are we talking? We're sitting at 113 million rand, and we still busy reconciling. We do have challenges regarding the reconciliation in terms of what is on the books and records and what is physically there that vests with SA Express. So to answer that question, we're talking in the region of about 130. Now currently in business rescue, owes SA Express in excess of 106 million rand as a debtor. So we're one of the creditors of SA Express. So if you have to take that I mean, as a creditor in a business rescue process as well, there can be no expectation of 100 cents in the rand dividend. So on the books, as we stand, we're talking about 200 odd million if we take in consideration the 106 million. The fourth point, to Honorable Somyo's question, the bond of security reduced. Yes, the bond of security was at 1.8 billion on an asset base. Realistic market, we've reduced that to 113 million rand. We are still doing a reconciliation, but honorable members, there is a massive discrepancy between what is known on record and what is actually assets on the ground. Then to go to with the licenses if they expire. Honorable Khatebe, that is a process that a prospective investor would need to quantify. We can give them the information. We can give them an understanding of what the airline, what it costs the airline to obviously be dealing with the value of the asset. Then the second element would be the cost of running the operations or restarting of the operations. And the third element would be, of course, the market-related issues would go, but that's the responsibility and obligation of whoever is really making the offer. So they would have to quantify how much funding they would require in order for them to restart the operations. Our point of departure or engagement with the example, there's then an investor who wants to restart their operations. In terms of legislation, we will then enter into what we call is a compromise. It's a 155 compromise. For example, if on final liquidation, if you're looking at the values, we've quantified a sale of 200 million and quantified that from those for 300 or 200 million rand, which will give creditors a better dividend than a final liquidation amount, then that can form as a basis for negotiation invest to restart the operations. What will happen if there's no residue? That unfortunately, Honorable Khadebe, it's the nature of then the liquidation process. If there's no residue, then there's no residue. If we've quantified, there will be no residue. At what stage are we at the investigating of the company affairs? Extremely early stages, honorable members. Using the bond, and now the next priority is to engage an immediate sales process. Then we can look at we've empowered ourselves with the 417, 418 inquiry. Then only we'll start dealing with the inquiry and focusing on the transactions that proceed with the sales process. Then the third step is to then look at the investigation into the certain transactions. This saves value. It costs money on a monthly basis if we don't conclude a sales process. We need to elect purely for a sale of the assets, because the leases, the current leases, are costing to the tune of no less than 24 million rand a month. Then Honorable Swartz, I just made some comments. You requested the details of the sales process. You will have the details of the sales process. That sales process will be published. We're going to follow a transparent process to procure that sales process, and we are in a position to do that. That was advanced by us. Honorable, no, I think I can put it out there. It really was something that we needed to do. We by the joint liquidators. That would be an administration expense. We will not be charging the company any interest for that advance, and those funds purely went to payment of the former employees who assisted us during the early stages of our appointment. Then Honorable Mente, the statutory provisions, you indicated what is the position there. Yes, these will be investigated. This will be investigated in the form of the 417, 418 inquiry. We will run that process. And if there's evidence, there's sufficient evidence, that direction as to what must happen further in transgressions, which at this point there's evidence, will then report it to the master, and the commissioner will give us direction as the liquidators. Are the directors still getting paid? No. There's no. The directors, they have been assisting us with all the certain books and records, but no previous directors are being paid. No one is being paid. Access of third party to lessors, etc. The lessors are entitled to access their assets. They're entitled to access. The assets do not allow to access their assets. This access to the assets is not access that is independent from the provisional liquidators. Any and all access is controlled, and we've said this to all the teams. They must please report those actions to us. But I want to say this, honourable members, as we are accessing these stores and doing the valuations, there's a lot of discrepancies. It's extremely difficult to reconcile the fixed asset register with what actually exists at these hangars. But everything is under the supervision and the control of the liquidators. Lighthouse West has cancelled their lease agreement because there's many other parts, etc., that we're reconciling in terms of, does it belong to a third party or does it belong to SA Express? So that's a process. It's under the supervision of the liquidators, and we're controlling that process. And indeed, the lessors are entitled to access of their aircraft. And then, Honourable Chair, you made a comment. I think I also, there is an issue of integrity regarding the financial documents that we have in our possession. And the reduction of the bond is a reflection of the integrity of that information. So we are working with what we have, and we've established, we're sitting with, at this point, about 113 odd million worth of assets that belong to SA Express. We have not had the privilege we're busy with. Thank you, Honourable Chair.
Right, thank you very much to the liquidators. Colleagues, I think that last point by the liquidator confirms the collective anxieties of all the colleagues. And I still believe that we do need a thorough session with DPE insofar as its own role is concerned. But I think for the purposes of today, obviously we're going to engage with the liquidators for the purposes of the process that is underway. But from where I'm seated, there are many questions which DPE has to answer. And I think that they need to take responsibility for what has happened. And the previous boards of the airline. And in the name of Cesar Zimela was cited by one of the colleagues who has now gone to Transnet. But you also had the long-time CEO, Inathi Nchanga, for about 7 years at the airline, and he made appearances. And these are the people whom should actually, at some point, in the immediate future, also be called to explain their own role before us. I certainly do not think you're dealing here about the sustainable livelihoods of 691 odd employees who now find themselves in a state of limbo because of mismanagement, corruption, amongst other things. So I think we have to consider very seriously the course of action colleagues we must take insofar as this is concerned. I know we are scheduling quite a number of inquiries with Water and Sanicom, SAA, but I think there will be merit here to keep a close eye on this process and to do a historic and age analysis and investigation of the fundamental role of DPE. All right, Honorable Dirks will be first off the bat for the follow-up questions, and then.
Thank you, Chairperson. Good morning, Chair. Good morning, colleagues. I hope I'm audible, that you can hear me. Comrade Chair, I'm audible. Comrade Chair, what I still want, I want to hear that somebody from the department can come on the public platform and tell South Africans in plain and simple English what brought us to where we are today, at this point of liquidation. Because this asset belongs to the public, to the millions of South Africans out there. And if myself and my colleagues are not out there, how will they understand what has brought us? And I want the South Africans to get answers from the department. The department needs to explain to South Africans what has brought us where we are here today. I'm a bit happy that the Deputy Minister have outlined some of the issues that have brought us here. He raised the issue about the emissions, but that is just one aspect of it. Because you see, Chair, it is wrong for us, for politicians, for everybody to shout corruption, corruption. Tell South Africans that through corruption that the airline is where it is today. And at the end of the day, no one gets prosecuted for that corruption. We cannot show this corruption. Where was that corruption? How was it carried out? And what measures has been taken to prosecute people that was involved in that corruption? Because we can't go in circles like this. We need to explain to South Africans what is happening in this airline and what has brought us where we are today. That's the first part of it. The second part of it is to the liquidate. But the liquidators here. So let me ask just a liquidator. I do not understand from the liquidator. I don't understand why are you liquidating and thereafter talk about the investigation. Should investigation not have started before the liquidation? Because I thought that you first do an investigation before you do the liquidated 1.2 billion rand, but now your current valuation is about 130 million rand. Now from 1.2 billion to 130 million rand. And then you also stated, yes, you have invested at the back of your mind because you have to, there will be investors that will want to invest in the airline. See, to be blunt about this matter, there is no intention of rescuing this airliner. The intention was always that the airliner must be sold, and the vultures were swirling around, waiting for the right chance. And now the time has come for the vultures to swoop on this airliner and get it for next to nothing. And this is basically what has happened here. And in future, if the department can please come back to us and explain to us clearly, step by step, what happened from the beginning until now that the airliner has been liquidated. Okay. Thank you, Chairperson.
All right, Honorable Hadebe. Thank you, Honorable.
There are a lot of questions that needs answers and will remain unanswered because the business rescue practitioner is no longer with us. They were cited, including the Minister of Finance, when the creditors launched an urgent application to place SAA under business rescue. Why they did not oppose? Were they also in agreement that SA Express needs to be under the business rescue? I, for one, where I'm seated, Chair, I believe that when the creditors launched an urgent application over and above that this company was in financial distress, but they also believe that there were reasonable prospect of rescuing this company. Otherwise, if they did not believe so, they would have straight gone for liquidation. And that it's also that there were several interested parties who showed interest in acquiring the entire airline as a going concern. They even went as far as signing a non-disclosure agreements. Now, for the business rescue practitioner to immediately rush to court and file for converting the proceeding to liquidation, yet there were interested parties that wanted to acquire the entire airline. To be answered. There is no business person that will be willing to put millions of money and investment into a business, almost 6 potential buyers. So it means somewhere out there is someone who sees potential in SAA Express, who sees SA Express as the business that can still be rescued and the business that can be profitable in future. Yet we had business rescue practitioners who failed to exercise their skills, expertise, and experience as a restructuring specialist to turn the situation around. So the question of having vultures out there, it's not far-fetched from the truth. We need answers. But now, liquidator, my primary concern is on the employees. We were told that the claim against the company were standing at 2.7 billion. And at that time, from the report from the business rescue practitioner, indicated that we had 1.9 assets, which gives us the net liability of 747 million. Now, if that's the case, meaning if there won't be any residue as indicated that employees are going to be paid from residue, it simply means that the employees won't be paid at all. Is that what are you implying? That employees won't be paid if indeed it happens that there is no residue? Our primary concern is for the employees who find themselves at the receiving end for the situation that they did not create themselves. Those who created this mess are now sitting comfortably in other state-owned entities, continue to earn salaries, and it's business as usual. The employees now are left for this company. Thank you, Honorable Chair.
All right, Honorable Liz.
Thank you, Mr. Chairman. Mr. Chairman, it is somewhat sad that Deputy Minister, instead of dealing with my questions, throws an insinuation, a question that I'm concerned about the costs and therefore the lack of dividends of an extended process of liquidation. And so let me leave it at that. And Mr. Chairman, I think you need to say so, and that the answers will be forthcoming in due course. And so my question about the value of these licenses remains apt. Aviwe has said that the asset valuation has been done. And I don't know who you're looking at, Aviwe, and who's giving you instructions in the background out of sight, but please concentrate on what this committee is saying. So that's one of the questions. The other question is very clear. I'm sure you have of what the costs will be for you and your team, including the 300,000, if the process goes on till the 9th. And then with regard to these 7 now, you say interested parties. Who are they? What are they looking for? Are they looking for just the licenses? Are they looking to take over the airline as a whole, including its liabilities? Are they looking to take over the airline, excluding its liabilities guaranteed by government? What exactly are they looking for? Surely you can give us an indication and tell us who they are. Where are these investors coming from? It seems to me highly unlikely that there are any serious investors. Another question, Aviwe, that any influence upon you and your team from the department or the minister or the deputy minister or anyone else for that matter in the way you deal with this liquidation? Mr. Chairman, I hear that the directors are required to assist. I mean, that we understand that. But why have they been assisting? I'm not sure why the directors who remain directors, because it's quite clear that this company is unlikely to pay a dividend. It will no doubt have sufficient funds to cover the costs of liquidators at the end. I can't see the liquidators playing Father Christmas and giving 300,000 Rand to the airline and putting all this effort in as an act of charity. So why are these directors staying? I don't know that, where you can answer that question, but I just need your reassurance that there is no incentive, financial incentive for the current directors or the remaining directors to remain directors, and they're doing so out of some sort of charitable concern. Thank you, Mr. Chairman.
Honorable Mente.
Hello, Chair. I want to follow up on the question of the investigation. In one of your roles, you specified it management that dealt with unscrupulous behaviors and spent the SA Express, and they spend it irregularly. Now you are saying in terms of 417 and 418 is under investigation and you will hand those names over when you are done. When will that take place and how long will it be? Because by the time you hand over the names of these people, you would have been done with your process of liquidating, and there's nothing that we can do in saving or getting them to pay back whatever they have taken from the aircraft. And then number two, Honorable Desk liquidation process has taken over already, meaning which or influenced by the conditions that were clear, or either a clear guidance as to there's nothing else that they can do, then we can only liquidate. Because once you liquidate, you are liquidating simply because there's no other option, and you are satisfied yourself as a liquidator that it cannot be saved, it must be liquidated. So when you are investigating and at the same time liquidating, what if then the investigations come out to a point where the company can actually save itself from where it is today? On the issue of the lighthouse, I'm glad that you answered that and you shed the light in terms of the lighthouse having to cancel its contract with you. But a person who have canceled their contract with you cannot have access to the stores of SA Express. I don't know if you are aware of that, or your team on the ground is explaining to you that they are fixing their aircrafts. They are fixing their aircrafts. Are they bringing spares themselves? Because they have full access to the stores of the SA Express. They can help themselves with the same assets you are trying to consolidate. And your reconciliation is going to be problematic until you have no third parties accessing any of the property. Because for as long as your property has got other people who come and go, things are going to get missing. Yes, the fixed register could be in a state where it does not speak to what you are having on the ground. However, if there's other people who have access to it, that's to the DM. I wanted to ask this earlier on, Chair. Am I still audible?
Yes, you are. Proceed. I'll let you know if you are not.
Okay. I wanted to ask this earlier on, Chairperson, but my network was not allowing me. Chair, there is a very disturbing way in which the department is explaining this process and what informed it to be at the stage it is today. One, when the BRPs came into play and they presented their document to appropriations where they were requesting some sort of funding in order for the company to operate, they presented something that gave options in order for the company to operate. And out of those options, I think it's the fifth or the sixth option is liquidation, which was the last resort. All the other options, there is no explanation as to what happened to them. There were other opportunities or alternatives that could have been undertaken by the department in order to save the SA Express. But due to the pressure of creditors and the court process, which they did not appeal, that still begs a question as to why they did not appeal it when they had options that could be an alternate in saving the company. There was also a letter that the department wrote, it's 764 million grant. So those conditions were either met or they were not met. The department must clarify this to us. What happened to their promise to assist the saving of the company? Was it because the conditions were not met? SAA. The minister indicated to the fact that the reason why they are never giving any money, and it's not the matter of them refusing, it was because the BRPs were not forwarding any business plan, which is a rescue business plan that was making sense to them. There was a draft at some point. Was there something of that sort where SA Express is concerned? Is it because the conditions were not met? If then the conditions were not met and therefore that 164 million was withheld on strategy, because this liquidation is not making sense. And on the issue of the board, you spoke at length as to this board was sitting in either quarterly meetings where they were viewing financial statements. Didn't those financial statements indicate that there were monies not being handed over to SARS? There were monies that were not paying insurances. So, and upon picking up those of the company, it's in charge of the funds that are transferred by the state to them. And for them today to be saved and be painted as the people that did something when they did absolutely nothing to save the company. In fact, they were part of the looting. So we need an explanation as to why were the financials using liquidation over saving the company? Why have we not exhausted all the options that the BRPs came up with? Or do you have a document where they themselves, none of them can come in to give us an answer? Why did you not appeal the liquidation? Last chairperson of my questions is with regards to page 18 and page 21, liquidators of your presentation, where you are giving out the actions to date, the title of actions to date. Part of them, you were speaking to unions. This question is aligned to what Honorable Hadebe was asking earlier on. You spoke to the unions. What was your view when the unions were talking to you at that point? Was DPE part of the process when the unions met with you? Because what is?
Thank you, Chair. Chair, my first comment is that the department chair must please urgently come, because when the business rescue was still here, which is a few weeks ago, the department was saying to us they put an exemption at Treasury for 1, 2, and 3, and 4, and not in the first round, Chair, was that the liquidators are just everywhere. They are selling at the same time they're investigating. The next thing they're doing this, but I want to ask Aviwe, Mr. Aviwe, that when you are saying the 300,000, you used it for administration, but you are directly telling us here as a committee that you were in fact paying employees at SA Express to assist you. How many of those employees were assisting you for you to pay them? And how you were not paying salaries? But because of your urgency to get information that you want, if I understood your English properly, is that you paid that 300,000 you are saying was meant to pay employees because it was urgent. You were paying them for urgent work. So I am asking you, when you were paying them for this urgent work, how were you paying these employees? How many of them did you pay? All the staff at SA Express to get this urgent work with this 300,000? Or did you choose those, as you are saying, you needed information from, and you paid them 300,000? And how were you now paying them this? Because they are not getting a salary according to what you are reporting. So at that stage, you contracted them as what? To do your urgent work. And if you are saying you are still reconciling books, you are saying that you are still reconciling books, but you are giving us figures of 113 million in asset investors. That is where you're hiding the money now, because you are still reconciling books, but you are telling this committee a figure of 113 million assets. So by the time you finish reconciling your books, this amount will still be standing there, unless I'm not understanding your English properly. Because which means that indeed the interested people here are not interested in a bankrupt able to say when Honorable Liz is saying that give us an estimate of where this whole thing is going to sit. No, you can't. And I think that, Chairperson, the department needs to really come back, because when we go back to our notes and everything we are being told, and every of boards we had, a whole lot of things, because we can remind them from committee meetings we come from, where we ask questions, where when you people just brush us away by responding to us in English. Mr. Aviwa, the company that is liquidating or that you work for, or you as a liquidator, have you ever before liquidated any assets of a government department, or is this your first liquidation job where in fact you are involved in liquidation where government is involved, or you've done it before? And if
no, thank you, colleagues. I think that what is very clear is we need to run it two parallel processes here. I still maintain, and judging out of what colleagues are saying, that there is the unexplained role, in as much as from an assumption point of view is very clear. That role is about the department, previous boards, and previous executives. And I don't get a sense that any of the three are taking responsibility for this, which is obviously we will have to engage with the department. And I think we will need to take it back a step, because of Big Brother, SAA. And therefore, for some time, they may not be on the radar, because, excuse me, there's a particular focus on SAA. And I think that we should have engaged, we'll have to take it back so that we can ascertain what informed the decisions to liquidate. Just purely from a process point of view. The question about who are the interested press are they interested in, it can't be left hanging. So I think we will need responses in that regard. Responses, but I fundamentally feel, colleagues, that the department should be honest with us here. Otherwise, sizodlala umjikajo in the previous boards and the executives. Those people, colleagues, will have to find time. I know our program is packed, as I was saying. I think we really have to find time and engage even on the audit reports afresh, because I mean it boggles the mind that the same DPE would transfer, for all intents and purposes, the former acting CEO to another entity. It doesn't inspire confidence. The DM spoke about the board of 2018. That acting CEO, Cesar Zimela, came in at that time. So if you're going to trace back the problems to 2018, which I think are far beyond that, if you look at the fact that when Inathi Nchanga left, the irregular expenditure was shooting through the roof, the wasteful expenditure was shooting through the roof, and the board at the time said that they had to let him go, and he was paid out some 770,000 rands to. Part of this has been a fundamental mismanagement dilemma. And the immediate people who are interacting with the entities is the department with all the technocrats, the experts, insofar as public enterprises are concerned. And all of this happened on their watch. I dare say we need to extend it to the point of the political principles, their roles in the decision-making which is taking place, whether it was interference or interface. So we can make a clear distinction between the two. I maintain no airline can just crash, can't. Right, DM will hand over to you and then we'll take it to the liquidators. I'll just be guided. I'm seeing in the meeting chat there's a hand, but it's not appearing on my side of who it is. Twice, going thrice, gone. All right, DM, over to you.
Thank you very much, Chair. Just to assure the we give, or at least in the responses I have given so far to the committee and all the time, it's always honest and with no intention to take the exchange for granted. So I would like just to put that across to the Honorable Committee again. I'm going to request that the acting DG, after I finish speaking in the exchange, I think it was Honorable Mente, specific to what is in the system representing the commitment that through DPE was to be availed to SA Express, and for what purpose that was for. I think there is Honorable Dex. I think at some point the point he is making, the Honorable Member, he is quite a valid one, in that at a time there needs to be an account in which, but I'm not properly delegated at this point. Of course, I may take this back to the department so that an appropriate expression is made in that respect, so as to really get to that. The limited time I've had interacting with this environment would have been the toing between the department, the entities concerned, as departments just simply decides what it has. Of course, you've got to meet a number of criteria, reasonableness as well as return on investment sometimes. I know that even the previous board, whilst I'm not speaking for the board, and I hope, Chair, in your an account of their actions in terms of their fiduciary responsibility. But at the point at which there was this attempt to introduce the business rescue process at SAX, it was when we were working with the board to try and get some funding from Treasury to help to really revive the airline, in the sense we believed the airline could be revived. When the business rescue process was instituted, external to the board, external to ourselves, at the instance of one creditor, we still held on to the view that the business can be rescued. But of course, that was predicated on fine number of reasons that led to inability to have that post-commencement funding, which then became a sticky point that when those rescue practitioners then went to court outside of us, we couldn't go and oppose them, in that we had to speak to the matter of where the post-commencement funding was at that point, in the way, in that sense. So that's why there wasn't that. I think I'm responding to, I think, Honorable Hadeb's point, as well as I think Honorable Mente has raised the same thing. Yes, there is this sense that this is rescuable. I think the COVID-19 pandemic then threw the spanner in the works in a way, in that then all the airlines were talking about it to be grounded once again. I think it really threw a spanner in the works to muddy an already muddied environment. I just thought, let me say that in principle, I agree we should come back, perhaps in a way so as to, as honestly as possible, respond to the questions, the concerns the committee has, the liquidators. Thank you, Chairman.
Acting DG. On the 164 million rands, this was a guarantee that had been provided to SA Express when it leased the aircraft from the lessors. Payments that government will step in and pay for those leases for a period of time. So that's how the 164 million rands was calculated and provided for in the 2020 budget. It is not intended to recapitalize SA Express. It's intended to, now that the risk that was anticipated is materialized, it is intended to pay the lessors in line with the guarantee that was provided. And those discussions are ensuing currently with the lessors to determine how that payment will be made. On the issue of the question from Honorable Dex, that DPE presents itself, and we remain where we explained our oversight system and what it can and cannot do. What has happened to specific entities in our under our care. And Chair, I just want to also prior to business rescue or liquidation, it has appeared on issues of annual reports that were not prepared. It has appeared on the issue of the financial challenges that it had. So the saga of S Express unfolded for quite a while. I'll say prior to 2018, when we had the board that has just left was appointed. So it's a story that is not confined to S Express. Should not should take into account is actually the corruption that has been very well articulated in various forms. There's many articles that have been written about corruption in our entities. The very bad appointments of executives and directors that were made at these entities. It is for that reason that we find ourselves here, where these entities were and their resources were hijacked for other ends, and which I will really say, Chair, the members are very much aware of. That's why we find ourselves here, and that hole has turned out to be much bigger than we anticipated to fill. Government in the last 2 years has put 1.5 billion rands in the SA Express. That has not helped, and that's why we are here. And a point as to the department, we have a responsibility as an accounting officer. I have a responsibility to ensure that I do not commit government to any expenditure if those funds have not been. There was no immediate window available to be able to appropriate funds to SA Express. And secondly, it would also have been irresponsible, and there's not been a credible plan up to now put before us that would warrant us going to those ends to put money into the entity. And I would say what we have been faced here is an entity that has clearly failed, and it's unfortunate that in the process it has impacted on people's livelihood. We have SA Express employees protesting outside our building here, because that's the reality of what they are faced with today, and would not be human if we're not recognizing that pain that they are going through.
But I think instead of pointing fingers, we need to be saying to us, Parliament as the second line, to ensure that our entities do not find ourselves here. What kind of mechanism can be put in place to ensure that we appoint the best people amongst to deal with? Because it doesn't help now to be pointing fingers when we know very well what happened and how these entities got themselves here. And I want to assure the members where there has been instances of officials cited, we have dealt with those within the department. Thank you, Chair.
No, DG, I think we'll be moving from a very incorrect premise. If we are going to want to say we must not point fingers, we have to point fingers. That is precisely what we would be a dereliction of duty if we didn't do. Because pointing fingers should lead us in the direction of who was responsible. And ultimately, the shareholder representative in these entities is DPE. And as you say that you are the first line of defense, we need to probe extensively and seriously whether the duties which are expected of you have been performed to the best of your efforts. We are not going to allow a situation where we are going to be. So we can't in good faith sit here and say we can't point fingers. Pointing fingers points us in the direction of accountability and over. Because then the question which would arise then, in the absence of pointing fingers, what do we do? How do we hold people accountable? I would imagine that DG, let's tread very carefully on that one. And it is precisely why we are here now. Maybe I certainly would not want to associate this committee with that kind of outlook, and would implore you as the department to begin a process of consequence management where you point fingers, hold people accountable. If you're speaking about appointing the best of the best, it's you who are doing that. Because if they're not appointing the right people, then that's why we have these problems. And what are you doing? No, DG. I highlight it as a major flashpoint of why we are here, because it certainly doesn't sit with me. Right, the Honorable Deb.
Chairperson, as the ANC chairperson, we will not accept that kind of response from the DG to tell us that we are pointing fingers. We are not pointing fingers here. We are here trying to get to the bottom of this so South Africans can understand what is executive. We are not running the airlines. We don't appoint people in the airlines. We are the legislature that plays our oversight role. And what we are doing currently here is we're playing our oversight role. We're trying to get to the bottom of this, what's happening in the airliner, so that South Africans can understand what is going on there. Because even the committee does not even understand what is going on there. So this is basically what we are doing here. It's not a matter of pointing fingers. It's a matter of trying to understand what is going on, and we cannot accept that that the DG comes and tell us we should not point fingers. That is totally unacceptable. We will not accept that. Thank you, Chair.
Honorable Chair.
Honorable Hart.
Yeah, perhaps I think the acting DG must assist us and expand on what he means by not us pointing fingers. Is he suggesting that we need to adopt a Panado or a grandpa approach? When you have a headache, we give you tablets, to the fact that we have not been able to employ the best of the best? I think that's, to me, that's pointing finger to the problem. Then we understand how then do we resolve such a problem. So let's give him a benefit of a doubt and give him an opportunity to explain what he means by pointing fingers. I do not want to assume that he was being defensive. Perhaps he was trying to advise us on something. So I don't want to be harsh on him. We are all in this together. Our efforts are geared towards solving the challenge. And if he feels we add in some form or another, let's then take in that good spirit. So I'm appealing let's give him the benefit to crucify the wrong Jesus. Thank you.
All right, we will take the Honorable Mente, Honorable Swartz, and Honorable Tolashe. The liquidator, if you can just bear with us a moment, and we'll come to you. Honorable Mente.
Thanks, Chair. Chair, I don't know if it was the 1st or 2nd of June. If you do have sight with the DM, if you do have sight of that document, read what does this 164 million I'm referring to is indicating there. And it's even conditional. So if it was what you are saying it is, why then you had to place conditions on something that is straightforward? It only goes to the leasing of aircrafts. But this one that is indicated on this particular document is speaking to something else. Number 2, the fact that your financials, even on those conditions of the 164 million, there is a line that's indicating to the fact that the financials of the 1.2 billion, which was allocated to SA Express, was unaccounted for. Until such accountability has been then undertaken, you will offer such 164 million to SA Express. So the fact that those financials were still not accounted for by the time the BRPs came to the business, it shows that we have to point fingers. Who did not account on the 1.2 billion? Who did not account to all the funds that were allocated and appropriated to the SA Express? Who are these people you are telling us about that you have charged so many officials? Who are those officials? What were they charged for? Are the people who created this mess, the crisis, that the financial crisis that the SA Express is finding itself in today? Who are those people that you have charged? On what basis? For which misappropriation of the funding that was allocated to the business? With those are the fingers that we're pointing, and we're going to point them. If you and your department do not have the monitoring and evaluations, and not come here to tell us, no, this is history, these people have been misappropriating funds. But what is your monitoring tool telling you? You can't sit on a quarterly basis with an internal audit committee and your division of monitoring and evaluation not giving you red flags as to what is the status of the financials of SA Express. Those answers, they're still relevant, and we still want to hear them. I hear the DM, Chair. The DM says there would be a day and a time where he comes to explain the reasons why we're here today. Outside his office, they were singing the revolutionary songs there outside. They are demanding answers. What you are telling us here today, they have no clear indication of what's happening with their salaries. You are telling us they are not hearing that. Go tell them that. Who's going to pay them their money? It remains your obligation, no one else. You can't rid yourself of such an obligation. They are your employees, and you are the one that must pay them. Thank you.
All right, Honorable Swartz, and then Honorable Tolashe, and then we'll give the DG an opportunity, and then the liquidator will provide his responses, and then we will round it up. Time is not on our side, colleagues. Honorable Swartz.
Thank you, Chair. Chair, I think that sitting here listening to the DG after the minister, and if the DG is reminding us that SA Express did come appear before us and gave us a presentation, so she must remember. So my comment is that the DG is telling us, Chair, how to do our work, and the DG is taking us to be an accounting officer like him in his office, when he is telling us that there should not be pointing of fingers, appear before us when deemed necessary for you to account, like in this instance. But when you are saying to us not pointing of fingers, not that, and everything else you are saying to us, and I just have an interest, what do you mean by that? We must remember. SA Express did come and give us a presentation. Thank you, Chair.
Right, Honorable Tolashe. Mamti, yes, we can. You can proceed.
Thank you very much, Honorable Chairperson. Good morning, everybody. Chair, in welcoming both the presentation by the Deputy Minister as well as the team. My questions are being covered by Honorable Mente. However, I want to add to say we need that detailed report of those workers. Which position are they holding and all that. But secondly, Chairperson, I guess I want to assume that the DG was not really telling us that we should not ask questions. I think they should not be asking questions. Instead, they give solutions. That I assume, Chair, because I don't want to really assume that he can come here and really disrespect all of us. The last one, Chair. Everybody knows for a fact that we are in levels of a democratic country. Just want to hear from the department what is this that they are going to do to make sure that those workers are being addressed and given facts. So this wouldn't allow them to be there, but we are risking their lives because those people are not supposed to be. We are in level 3, Chair. There's everything that should be followed so that people, because those, as we have alluded for the fact that are their workers, and we are a democratic country. We can't allow this to happen forever. Whilst Liquidator is saying they are still in early stages investigation, let the workers know what is really happening so that they are not being held on ransom by yourselves for your benefit at the expense of them as workers. Thank you, Chair.
All right. I think members have adequately framed our outlook with the reaction to the comment by the acting DT. I'll give an opportunity now to respond, and then the liquidator can come and give his responses and concluding remarks.
Thank you, Chair, and apologies to the members. I think maybe English left me there. My apologies. Now, what I meant is that we are the first line of oversight, and it's only proper that we come and account to yourselves. And I just want to assure the members, Honorable Mente spoke about the monitoring and evaluation process, that on a quarterly basis, we do get reports, which obviously we analyze and we provide advice to the shareholder representative in terms of how we should be reacting. And with regard to entities that are in distress, we do that. The deterioration in the affairs of this business happened over quite a long period of time, and it turned out to be much deeper than we anticipated. And I apologize for maybe I used inappropriate words there. I was in no way suggesting that we should not account. And I want to also say to the honorable members, we had one instance of an official that had been seconded to the entity that had found to have acted improperly. And in the midst of taking action against the said official, he left our employ of the department. But that work is continuing, and the reports have been referred accordingly. Honorable, the 164 million rands, when the letter was sent, was prior to the business rescue, and ordinarily that such a letter when it has the appropriation has been made in anticipation. But now that we are here, the mechanism of addressing that risk of the lessors can no longer be addressed through the process that was anticipated by that letter. So a separate process currently being negotiated with the lessors so that we can do good by that liability. Thank you, Chair.
Thank you, Honourable Chair. Just to then respond to the second round of questions, there was a question from Honourable Madeve. The question regarding the sensitive issue regarding the payment of employees and the likelihood that indeed will there be a residue payable to them. Honourable members, it is unclear at this point that there will be a free residue payable to satisfy the employees' claims. If I give you by way of example, if indeed Kale, the airline exceeding that amount, and there's an unlikelihood that will happen. So at this point, it is unclear. However, that doesn't preclude any party coming in to take cession of those claims and actually making payment and satisfying those outstanding employee claims. Then moving on to Honourable Lees. Thank you, Mr. Honourable Lees. Sorry, I omitted there, Mr. Lees, to Honourable Member to deal with the licenses. Derek, there is no value to the license as is because the licenses are untransferable. In fact, to the extent that the outstanding amount regarding permits and payments for the licenses is to the tune of over about just over 4 million rand. So if the valuation that we currently have doesn't deal with the value of the license, but what is the actual value? There is no value in the license. Now, why do we want to keep these licenses active? So that we don't exclude the option of attracting an investment of the entity or a party buying the entity as a going concern. What will happen is that if there's an offer for a buying concern, we'll enter into what we call is a 155 compromise, which then, because the license is vested with the entity, that investor would essentially buy the company, compromise the creditors, buy the entity, and then those licenses would vest with that new investor. The cost of liquidation is in accordance to a tariff. Now, in my understanding of your question, the expenses, the time period that the implication of the time period, 1 million rand, that is an immediate consideration that we're going to be considering now, since we've extended our powers, in light of us engaging the sales process. Our 6% fee on that amount. If we sell movable assets of the business, the liquidators earn then 10% of the total sale of the immovable property. If we restart operation and trade in liquidation, the liquidators earn 6% of the turnover in a trading scenario. The interested parties, we are signing currently confidential NDA agreements. I will give a report to the department and to the committee regarding the detailed interested parties. There's 3 parties who are interested purely in the sale of the assets, and then the balance of the other parties are interested in looking at options of investing in the restart. Purely is a shareholder. It's not regarded as a creditor. Indeed, we'll have to engage when there's an equity investors, because the shares of the airline vest with the department. So with any prospective investor, if indeed they want to invest or buy equity, would have to consult the department, because the shares vest with the department. The other influencing factors is going to be the body of creditors that have proved claims. So any offers, any interested party will have to go, yes, via the shareholder in their capacity at the department, their capacity as a shareholder, and of course the body of creditors. So that's the extent in which the influence is with regards to the shareholder. Then I think Honourable Mented dealt with the liquidation after the sales process. What will happen? Honourable members, we can begin the inquiry at any point in time. I think it's a question of costs and the availability of funds to proceed with that inquiry. Under normal circumstances, we would have to quantify the cost of the inquiry, recover funds, and the cost of that inquiry. We can begin with that inquiry at any point in time once we are ready, but there's a cost element. So if, for example, we proceed immediately with a sale, then there's funds in the estate or in the company, then those funds will be utilized, a portion of them, to do the investigation or to do the inquiry, but then there has to be an element of prospects to recover actual funds from those particular individuals or particular whilst we're busy with the sales process. The issue regarding Lighthouse and the full access to the stores, there are third parties that South African Express Airways has their parts. Now, what is with SA Express? So the process is these third parties want to lay claim to their parts, but there was a lack of record keeping. That's why we would then allow them to come to the stores under the supervision of the Provisional Liquidators team. It's not the parties just there alone. It's still under the supervision of the. So we're trying to do then those recons to determine what belongs to third parties and what belongs to the liquidators. Then yes, we engaged with the unions, and in our meetings with the unions, it was purely the meetings with the joint liquidators and the department in one restart, or alternatively a sale where there will be a free employees. That's the current position of the unions. Now to go to Honorable Swartz, liquidators, why did we pay them? The provision of the discretion to employ certain technical expertise from a company. We are certainly not aviation experts. So in order to fulfill our obligations, we do require certain technical expertise. Naturally, what would happen would appoint purely to be done. I will produce a report of the functions. It's limited duration. We call it limited duration, and how many are there and how much we have paid them and what assistance they are providing us. Have we dealt with a liquidation in government? It's uncharted waters in the industry, both from the business rescue and government is a shareholders. It is indeed uncharted waters. I'm not aware of any other matter where there was a liquidation of a government. I think, Honourable Chair, that's on the second round.
Minister and the ministry, DG, the problems before us are huge, and probably that is an understatement. They're ginormous, and their impact is going to have far-reaching consequences. As already the workers are outside the DPE, and it speaks to a process which, of course, and I certainly think that the RNA must not be lost. The fact that workers are out there right now at this very moment of the situation, and something is also about moving with the necessary speed, Mr. Liquidator, to bring all these matters to a logical conclusion, which provides certainty for you. The extensions raise an eyebrow for us, and we will continue to be monitoring the speed with questions that we have posed to you. So those will be following up for written responses. So that as the meeting has been going on, would have pointed to a direction in terms of how we move forward from here. But I'll request that we will have this. But I think we need National Treasury here to, amongst other things, explain its role and probably some of the decisions that they have taken insofar as finance is concerned for the airline. And then colleagues because I think we run the risk of having consequence management evade us, judging by the tone and rhetoric which is transpired in this meeting on one hand, but by the general lack of consequences SOEs. So we will have to call a set of actions, decisions, and department in itself will have to appear before us outside the liquidators and the business risk. If we are to create a department is conducting some of its operations, really need to so is negated to sit down with the with public enterprises as a department. Can't have SOEs collapsing left, right, unprecedented levels of consequence management. There's no movement in the operations of the department in order for it to inspire confidence, because that's the center. This week we're going to be having ESCOM. We're dealing with matters there as well. We still have to interact to Transnet, you know. So it's quite clear that we went so that we can get the ball rolling properly. So I will request to do is that colleagues, all the issues that you have indicated here, we're going to enumerate them into correspondence and send them through to the department and the liquidators. And then they can provide those responses by next week, Wednesday. Side is to begin a process of scheduling the hearings of the format with the department. When the law enforcement agencies come in, particularly the anti-corruption task team and specifically the NPA and the SOEs are concerned, but with a particular focus on SAA and SA Express, so that they can bring us taken place. So we really need to put the pressure on all the law enforcement agencies also to arrest. So DM, I'll hand over to you if you want, understanding that we are going to provide.
Chair, thanks. We look forward to that program. We would then come and avail ourselves to any further engagements in this regard. In respect of the employees from SAX that are in the premises or next to the premises of the department, we will endeavor to engage them meaningfully so as to create a sense of understanding what is possible, what can we do in respect of the thank you very much, Chair. I'm pressed for another meeting that should have.
Thank you very much. By tomorrow, and then we'll send through the correspondence by close of business. Mind that Parliament we're going to be going into a recess of sorts. So let's have by the end of the term tied down on all these matters, but before us, and it remains of ours here is about safeguarding the public purse, taxpayer any more than it should. We can't have a situation where there's an assumption that the resources of the taxpayer are, and that we will be monitoring whether this is being done correctly and properly and with the necessary speed, and not being drawn out to milk the public purse money-making scheme. This is about saving. We will bring the meeting to a close, and we will communicate the dates to DPE as to when they will be coming in for a hearing about their own operations and how they are handling communication oversight is concerned on the SOEs. We need to unpack that. You be let off the hook, nor should they get a slap on the wrist and then it ends there. They need to themselves account for their own actions, and as I said, whether constructively or destructively, whatever they've done, we need to unpack that as well. So colleagues, let's prepare for that. So on that note, thank you very much. And just to remind members that this House will be sitting at 1,500 hours this afternoon in this week.